Constitutional identity is a topic of increasing importance in understanding the interaction between the EU and its member states. If the European Union shall respect the national identities of the member states, according to Article 4, Paragraph 2 of the Treaty on European Union, it must, of course, know what's behind the national identities. And for that reason, I thank you very much for inviting me and organizing this seminar in difficult times. Perhaps before I start with my presentation, I also would say that I agree with your first remark. My presentation will perhaps show that a new institution on the European level for a competence conflict will not really solve the German constitutional problem. The European Court of Justice and the German Federal Constitutional Court have a fundamental different understanding of why union law takes precedence over the law of member states. Since its landmark decision in the case Costa versus Enel, the European Court of Justice emphasizes the autonomous character of union law and claims that it takes precedence over any norm of national law, including constitutional law, by virtue of the independence and autonomy of the EU legal order. Otherwise, so the argument, the requirement of uniform application of union law cannot be guaranteed. The German Federal Constitutional Court has recognized the primacy of union law in principle. From the German court's point of view, this priority, however, is neither absolute nor genuinely union law, but one that is conferred to the EU by its member states and is thus constitutionally anchored and constitutionally limited. While the German Constitutional Court accepts the primacy of EU law over national law, including constitutional law in general, it does not arrive at this conclusion through the rationale of the European treaties being an autonomous source of law, which is the view taken by the European Court of Justice. Instead, the German court considers that the primacy of EU law has its foundation in the legislative act, which means the German Act of Approval, which provides the mandate to apply EU law. This act is in turn based on Article 23 of the German Constitution, which allows the German parliament to transfer powers to the supranational level, and as a result, the primacy of EU law only extends as far as the Federal Republic of Germany has approved this supremacy rule on the basis of the current constitutional order. If we don't change this article of the Constitution, and it would have to be changed by a referendum, any institution on the European level would not solve the problem. It was in the 1970s when the German Constitutional Court was confronted with a constitutional dilemma. On the one hand, the Constitution allows for German integration within the system of international and supranational organizations. On the other, the so-called eternity clause, let down in Article 79, Paragraph 3, basically says that amendments to the basic law affecting the principles let down in Article 1 and 20, namely the principle of democracy, the rule of law, human dignity, and the core of human rights, shall be inadmissible. Against this background, the Constitutional Court rendered its famous Solange 1 judgment in 1974, establishing and elaborating upon the concept of constitutional identity. Reviewing a community act against German fundamental rights standards, the court stated that the Constitution, I quote, does not open the way to amending the basic structure of the basic law which forms the basis of its identity. In its Solange 2 judgment in 1986, the court ruled that the Constitution would not allow for an interference with the identity of the prevailing constitutional order in force by intrusion into the Constitution's basic framework, that is, into its constituent structure. In the Maastricht judgment, the court concluded, I quote, "Since democratic legitimation is by necessity effected by the parliaments of the individual member states of the European Union, the German federal parliament must retain functions and powers of substantial importance. The court did not, however, provide a list of such substantial functions and powers. It was only in 2009, in its famous judgment regarding the Treaty of Lisbon, that the notion of constitutional identity resurfaced. The court considered German constitutional identity the crucial yardstick that had to be observed whenever Germany was to transfer powers to a supranational entity such as the EU. Considering the basic law's overall open character towards international and European law, this does not mean that a predetermined number of certain types of sovereign rights should remain in the hands of the state. However, European unification may not be achieved in such a way that not sufficient space is left to the member states for the political formation of the economic, cultural, and social living conditions. Quite remarkably, the court then substantiated 5 domains which would have always been particularly sensitive for the ability of a constitutional state to democratically shape itself. It listed decisions on substantive and formal criminal law, on the disposition of the monopoly on the use of force by the police within the state and by the military towards the exterior, fundamental fiscal decisions on public revenue and public expenditure, decisions on the shaping of living conditions in a social state, and decisions of particular cultural importance, for example, on family law, the school and education system, and on dealing with religious communities. The Constitution would not completely bar a transfer of powers in this democratic primary area, but such a transfer would be particularly sensitive. I myself, in academic articles, heavily criticized this ruling since the court did not supply any reasoning to corroborate its findings. It has no basis in the Constitution. The 5 domains are, simply put, an invention by the court. More convincing, perhaps, are the rulings on the measures taken by the euro crisis. In its decisions on the European Stability Mechanism, ESM, the court reviewed the constitutionality of Germany's participation in the setting up of European rescue packages in the wake of the sovereign debt crisis in the euro area. The court asserted, I quote, national budget autonomy as an essential competence which could not be relinquished of the parliaments of the member states which enjoy direct democratic legitimation. The members of the German parliament would have to retain control of fundamental budgetary decisions, even in a system of intergovernmental administration. So far to the situation when transferring sovereign rights to the supranational level, and here you can see that without a change of the constitution, without a referendum, it would not be possible for Germany to ratify a treaty which would establish an institution on the European level which decides about the competencies. The second tool of the German Constitutional Court is the so-called Ultravirus review, which you mentioned in your question. The Ultravirus review concerns competence questions of the European Union. In carrying out an Ultravirus review, the court exercises its right to examine, I quote, whether legal instruments of the European institutions and bodies keep within the boundaries of the sovereign powers accorded to them by way of conferral, whilst adhering to the principle of subsidiarity under community and union law. However, reacting to massive criticism from not only German, many other academics and lawyers, the court, in its Honeywell decision in 2010, developed a more balanced approach for the Ultravirus review, and that is very important. The court said, I quote, a breach of the principle of conferral is only manifest if the European bodies and institutions have transgressed the boundaries of their competences in a manner specifically violating the principle of conferral. The breach of competences is, in other words, sufficiently qualified. This means that the act of the authority of the European Union must be manifestly in violation of competences, and that the impunged act is highly significant in the structure of competences between the member states and the Union with regard to the principle of conferral and to the binding nature of the statute under the rule of law. Moreover, an Ultravirus review implies, I quote again, respect for the Union's own methods of justice, to which the Court of Justice considers itself to be bound, and which do justice to the uniqueness of the treaties and goals that are inherent to them. Taking these restrictions into account, the Ultravirus review may be defined as a kind of safeguarding responsibility, according to which the German Constitutional Court is only able to act if absolutely necessary through a dialogue and in loyal cooperation with the European Court of Justice. Of course, everybody sees that here is the risk of misusing this review. Finally, the third tool of review is the identity review. This is now in the situation when the treaty is already in force. This view refers to an exercise in which the court determines whether the inviolable core content of the constitutional identity of the basic law is respected. In its OMT judgment on the outright monetary transactions of the ECB, the court has clarified the relationship between Ultravirus review and identity review. They are not supposed to be separate mechanisms. The Ultravirus review is regarded as a subcategory of the constitutional identity review. The details would be too complicated for now, but pursuant to this line of reasoning, any breach of competence constitutes a violation of the principle of democracy, as it violates the act of approval. If an institution of the European Union is using a competence which was not transferred with the act of approval, it's in the same time an infringement of the principle of democracy because the parliament didn't vote for transferring those rights. By giving way to this line of thought, the court has resolved that the Ultravirus review is substantially a part of constitutional identity control, since constitutional identity includes the basic elements of the principle of democracy. In other words, if the European Union or any institution of the European Union acts outside its competencies, the measure taken is not covered by the act of approval and therefore has no democratic legitimation. The German Constitutional Court regards this lack of democratic legitimation as an infringement of the constitutional identity. The result of an Ultravirus Act violating constitutional identity is that it is not binding on German authorities. In consequence, German constitutional bodies not only have to refrain from applying such acts, but moreover, they have a duty to actively ensure respect for the European integration agenda as set out in the Act of Approval by preventing such acts. Now, on the final part of your question, how did these guidelines of the German Constitutional Court shape its judgment of the 5th May 2020 concerning the public sector purchase program of the European Central Bank? Well, the general question the German Constitutional Court had to answer was whether the European Central Bank was acting within its mandate. The Central Bank's mandate is set out in Article 127 of the Treaty on the Functioning of the European Union. Under this provision, it is the primary aim of the European system of central banks to ensure price stability. To the extent that this is possible without affecting the goal of price stability, the European Central Bank shall support the general economic policies in the Union. It follows that the ECB is primarily responsible for monetary policy, while economic policy is preponderantly within the competency of the member states. So, for that reason, the ECB should have demonstrated that its monetary policy is proportionate to the effects on member states' economic policies according to Article 5, Paragraph 4, Treaty on European Union. In this regard, the bank has a wide margin of appreciation. It has, however, provided no such weighting. Since the European Central Bank has not come forward with anything on this, by the way, it meanwhile did, the European Court of Justice had no basis to conclude that this delimitation of competences has been considered by the European Central Bank. That the ECJ has nevertheless come to the conclusion that no legal issue relating to competences exists is, in the eyes of the German Constitutional Court, simply no longer comprehensible. The core problem of the case was that also by the standard of union law, it is methodically untenable to not elaborate whatsoever on the question of competence at all. The European Central Bank is independent in its monetary policy and has a wide margin of appreciation. The European Court of Justice can limit itself to a very relaxed standard and an examination of manifest errors. However, it must not completely ignore the question of competence, and that was the case here. In doing so, it blatantly fails in its task to monitor the application and interpretation of the treaties under Article 19 of the Treaty on the European Union, and the German court could but judge the European Court of Justice decision to be inapplicable in Germany. Meanwhile, I think the problem is resolved since the European Central Bank has demonstrated that, of course, it has done this proportionality test, in my opinion, also in the right way. Why it didn't make that public before and why the European Court of Justice acted in that way, I really don't know. The judgment, as you know, was heavily criticized. But I think if in the future the European Court of Justice engages more constructively with criticisms from member state courts and establishes a level of control for questions of competence that is consistent with the democratic and constitutional structure of the Union, that might minimize the reservations expressed by national courts and, in particular, I think most important, help to create a European legal culture that will strengthen the European Union in long term. I thank you.